often the substantive requirements of IDEA get turned upside down. And this notions of sound educational policy, I think, is a good example. In my experience in the disability rights world of the courts, I've found that there are basically two types of judges. The judges who are open, who get excited when they hear about the potential and possibilities for people with disabilities. And there are those whose reaction is, don't confuse me with challenges to my stereotypes. And I think that happens in the evidentiary hearings we have within the IDEA system. There are many hearing officers for whom this idea of not challenging sound educational policy means not challenging their notion of what constitutes sound educational policy. And that often winds up being just blind deference to the school district, but what it really means is ignoring what we know from research and practice, good practice, practice that gets results. And I think, listening to Frank, I kept coming back to the biggest challenge that I seem to face in these proceedings is that the decision makers, because IDEA has an administrative system of often dedicated hearing officers who don't do anything else but IDEA cases, and they come to think that they know a lot about educational practice. Most of them are lawyers, at least in Pennsylvania they all are, but they come to develop their own sets of beliefs about sound educational practice. Anyway, to me, what is really significant about Andrew F., in addition to all the things Frank said, is that it completely reverses the pattern we've seen in the courts in the last, 15 years or so, of gradually interpreting every requirement of IDEA as a procedural requirement. And the importance of this is that in 2004, Congress codified the holding of a number of courts that you can't get a remedy for a procedural violation of IDEA. I can remember hearing this from Senator Gregg's assistant, who was very enamored of this idea that we need to codify this and make it clear. And so there's a paradox within IDEA. There are, 700 odd procedural requirements in the statute. Somebody ought to do something about that, maybe. Since you can't get a remedy for them, why have them in the first place? States enforce those requirements through their monitoring systems, often to the exclusion of any kind of requirement for change in the case of substantive violations. Meanwhile, parents have no remedy for procedural violations unless they result in a denial of FAPE, which takes us back to the often subjective standard that is applied in these cases for what is FAPE, and I'll get to that in a minute. But school districts can prevail by showing only that they've met the procedural requirements of IDEA. If they have something that is called an evaluation, if they have an IEP, a document called an IEP, if they have, gone through all the procedures, presumptively they've complied with the statute. It doesn't matter whether the substance of what results is really of any benefit to the child. So that's a paradox. Some examples of violations that have been labeled procedural and no remedy awarded that come out of decisions I've seen in the last few years. Failure to reevaluate in a timely fashion, delay in developing an IEP, failure to update an IEP, failure to provide progress reports, failure to conduct a functional behavioral assessment for a student who has challenging behavior, failure to include specially designed instruction in the IEP, denying parents access to their child's education records, and my favorite, in the Third Circuit, we have something called the Oberti standards. There are counterparts in most of the courts of appeals around the country. And the first prong of the standard is that in the IEP meeting, there must be a discussion of the full range of supplementary aids and services that can make it possible for the student to be educated in general education classes. And there have been decisions that have held that that is a mere procedural requirement. And the fact that they never had that discussion doesn't mean anything. That's only actually my second favorite. My first favorite, which is a case that I have on appeal now in federal court from a hearing officer's decision, the child had no IEP. The district they didn't offer an IEP. They wrote a letter in which they had a consultant list some things that they were thinking of doing if the child should come back to school and they needed to have a new IEP. The hearing officer held that that was enough, that an IEP is, an actual written IEP is a mere procedural requirement, and it didn't deny FAPE not to have it. So this is kind of how far we've gone down this road of procedure versus substance. And the great thing about Andrew F. is that it focuses on the substantive requirements of IDEA. And I owe a great debt to Alan Coulter, who, in connection with a case called Emma S. versus Eason in California, spent a lot of time working with the state of California to figure out how to do substantive monitoring under IDEA, not just the procedures, but whether kids were getting any educational benefit. And he developed a process for doing that is objective and can be done with a little bit of training by monitoring teams. And I don't know whether this is an advantage or disadvantage, but I spent a lot of time in litigation against state institutions where everybody is supposed to be getting active treatment, which is the equivalent of educational benefit, I guess, under IDEA. And the ICF regs are very clear about the process. You have to have a comprehensive evaluation, and there are, terms that are thrown around that everybody talks about all the time, and so they're sort of on people's minds. Even if the programs aren't very meaningful, at least people know how it's supposed to be done. So there has to be a comprehensive evaluation, and this is very clear under IDEA, that the child has to be evaluated in all areas of suspected disability, and the evaluation has to be thorough and comprehensive enough to actually identify the student's educational needs and to look at how the child is progressing or can progress in the general education curriculum. So it's not just evaluation for the sake of doing an evaluation. And evaluations like IEPs are very formulaic in most cases that we're familiar with. There are IQ scores, there are scores on the Wyatt or some other test of achievement. Everybody weighs in and puts their piece in, and it's a patchwork, and nobody ever really pulls it together to look at who is this child and what does she really need to move forward. So there has to be a plan that is based on the evaluation and addresses the needs arising from the evaluation that are identified by the evaluation. The goals in the IEP have to address those needs. The services have to make it possible for school personnel to address those needs, the specially designed instruction, supplementary aids and services, and so on. And there has to be an assessment of progress that enables us to know whether the child is making progress or not, which is the fundamental requirement that individual circumstances. And if the child isn't making progress, you have to revise the IEP, add services, change services, do something to make sure that the child does receive progress. And these are all explicit requirements within IDEA. Most of them are in section 1414. And because IDEA is so detailed and complex, it's often a little difficult to pull them out of the statute. But it may be in the next round. Well, I don't know, I'm not very optimistic about the next round of IDEA amendments. So I won't even go there. But it would be nice if the statute could be a bit simpler about that. So Andrew F. Followed the decision from the 10th Circuit that the Supreme Court reversed was a good example of the trend in the courts and in administrative decisions to cherry pick requirements of IDEA and not to look at this this sequence of components of educational benefit in any kind of clear and logical way. Andrew F. was a child who was capable of doing very well academically. He had challenging behavior, which the school district failed to address. So there you have the substantive violation of the duty to do a thorough evaluation. And he didn't have a positive behavior support plan. Second violation, he didn't have an IEP that met his needs. However, the court looked at the fact that he was able to progress from grade to grade and never looked at whether the IEP addressed his unique needs. And I think perhaps due to some effective amicus work by Celine Almazan from COPA and her colleagues, the Supreme Court didn't take the approach that the plaintiffs took in Andrew F., which was to look at the quantum of educational benefit that students are entitled to. Is it more than a trivial benefit? Is it a meaningful benefit? You could struggle with those concepts forever. But instead, the court just went to the individualization requirement. And I hope Tom talks about what he did as Secretary of Education in Pennsylvania to stop people from using acronyms. And it's good to see the Supreme Court pick up on that. So the 10th Circuit held that Andrew F's IEP was okay, and they had not violated any obligation to revise the IEP because he had either met the goals or he hadn't. And if he hadn't met the goals, then he just needed more work, so that was okay. So there was almost complete deference to the school district on that, but more to the point, there was a complete failure to apply any kind of professional standards or ask what those standards might be. And there is a requirement in IDEA that goals be consistent with research, which is something else that's more often honored in the breach. An example of the kind of decision that I think is now precluded by Andrew F. is the approach that the Fifth Circuit often takes, which is to isolate progress from the underlying evaluation, the underlying assessment of the child's needs. And if the child has made any progress in any area, it's probably, that court is probably going to find that the child received an appropriate education. An example is a decision by the Fifth Circuit in a case called Klein Independent School District versus Hovem. And it concerned a child who was very smart, but he couldn't write at all. And so the school district's response was to just not have him write. He just never had to write. And they would put him in classes where he didn't have to write. And because he was very bright, he graduated from high school. He moved from grade to grade, but his needs were never met. And the Fifth Circuit went so far as to say that it would be an error as a matter of law to focus only on the child's needs arising from his disability. In other words, if the student couldn't write but was okay in math, the fact that he did well in math is the benefit that they should look to. So that's kind of the polar opposite of what the Supreme Court held in Andrew F. So I'll stop here and turn it over to Barbara.